Getting what you want in nursing home discovery. Stick around. Hey out there, welcome back to the Nursing Home Abuse Podcast. My name is Rob. I will be your host for this episode. Today we are talking about the documents, or rather the categories of documents that you may want to get in your nursing home cases, and perhaps what to do if you do not get them. But we're not doing that alone. We have the fantastic trial attorney, Suzanne Fink, with us today to get her perspectives on nursing home discovery and filing those dreaded motions to compel. So stick around for that. But first, it's time for the nursing home regulation question of the week. This week, the difficulty level, I guess, is pretty low because theoretically, you've got a 50-50 chance of answering it. So if you do get it right, give yourself 25 points. True or false? Under 42 USC 483.10D, the resident has the right to choose his or her attending physician. True or false? And that answer is true. Every single nursing home resident under the federal regulations has the right to choose their own attending physician. All right, and now it's time for the ChatGPT generated nursing home regulation joke of the week. Just remember, folks, general reminder, this is AI's attempt to blend humor and United States code. So set your phasers to probably disappointed. Gene, can we cue that up for us, please?
The ChatGPT generated nursing home regulation joke of the week.
Skynet.
Regulation 42 USC 483.70D insists on a governing body for nursing homes because nothing says fun like a group legally obligated to party with us. All right, team, who's responsible for the bingo fiasco? Finally, folks who can't say "not it" when the karaoke machine breaks down.
And further proof, folks, that the singularity is at least a few Olympic Games away. All right, now it's time to get into the meat and potatoes of the episode, folks. As I mentioned a few minutes ago, we're going to have a conversation with Suzanne Fink, a fantastic trial attorney. Suzanne Fink, a magna cum laude graduate from Auburn in 1984, attained her law degree with merit from Emory in 1987, where she actively participated in the moot court team. Serving as a blue and gold officer for the United States Naval Academy, Suzanne transitioned into law, practicing defense law, and as House counsel for State Farm. Since 1997, she has been of counsel at Lori Chance Forlines Carter and King, dedicating her practice solely to nursing home abuse litigation. She is just the most recent guest from that prestigious nursing home abuse law firm. And we are so lucky to have her talk with us today. Suzanne, welcome to the show.
Thank you, Rob. Nice to be here.
Man, I was just I was talking to you about this before we started recording, but I've been wanting to have this conversation with you for a long time. You specifically, but your firm is fantastic. But you're a legend to me as far as I'm concerned in terms of chasing down nursing homes for documents, and we're going to get into all of that. But I wanted to kind of start off with just a general question, which is to say, what are the documents that you would say are critical? Like, what are the must-have documents in a typical nursing home case that you want to get?
Well, there's a lot of documents that you need to get to prove your case. But if I had to break it down into 4 or 5 categories, and ironically, it's the documents we always end up arguing over and ending up filing to a motion to compel. But category 1 would be the policies and procedures of the nursing home. You cannot get those pre-suit. Our expert always wants those. You need to know whether the nursing home, for example, in a wound case, had policies about prevention of pressure injuries and how they stage pressure injuries, because 99.9% of the time, when you go and depose the treating nurse at the facility, they haven't followed those policies and procedures. So you definitely need to get the policies and procedures. Wound case, obviously, skin assessments, prevention, fall cases, fall risk. It's case specific, but obviously you're going to know what policy you need. Oftentimes they'll fight that because they'll claim it's some sort of business document. It's, protected by some business theory, and it's not. At the end of the day, it's just not. And you'll be able to get it. I've never had a court deny me a policy and a motion to compel. So that's category 1. Category 2 would be the personnel files. Certainly of the treating nurses, the names you see a lot in your client's chart, the administrator, the director of nursing. There's no doubt in Georgia, those are subject to discovery. You'll get pushback, but you'll win on that as well. And within the personnel files, you need to make sure that they've given you whatever training that particular individual may have had, as well as write-ups, issues at the facility and whatnot. So that's the second category we get, bar none. The third would be the training. And by training, I mean not only the sign-in sheets for the training, but what training did these nurses have in whatever category case you have. For example, I keep going to wound because that's what I see the most, these pressure injury cases. But what training do they have for the prevention of wounds? How often are they doing this training?
And not to interrupt you, but when you say training, you're not talking about like the schooling or whatever they needed to get their certification to be an LPN. Or whatever. You're talking about in services, right?
So, as lawyers, we have to do continuing legal education training. We have to go get our hours from the state bar, and then a doctor has to do training. Well, nursing homes, 90% of the time, have in-house training of their staff, all the ways from the CNAs up to the DONs. And the training can encompass a wide array of things, but depending on what your case is, you want to see whether they're training them and updating them with the newest standards. And a perfect example is, in the pressure industry world, those standards changed a few years ago. And I found in a lot of my cases that the nurses didn't even know that, which, helps your case.
Right.
If they're not up to date on the newest, latest and greatest, standard of care for a wound case. But training would be the sign-in sheets, the documents used by the facility. In other words, did they put up a PowerPoint? Were there photos used in the training? Did they hand out brochures? For some reason, I'm getting a lot of pushback on this lately, and I'm not sure why, because again, there's no question it's discoverable and relevant, certainly in the discovery phases. So that's category 3. Category 4 is the big one that we get the most pushback in, and I've never, ever, ever had any defense attorney say, sure, here you go. Right. It's the other resident records / other resident incident report category. And I found in speaking on this issue in other states that other states, the law is obviously different, but attorneys don't even think to request that. And let me explain to you why we request that. More often than not, Rob, these facilities have a chronic issue, whether it's low staffing, failure to train, call-ins resulting in people not showing up. But people are hurt at these nursing homes for a multitude of reasons, but what it usually comes back to is a chronic ongoing issue the nursing homes are aware of, whether it's short staffing, improper training, whatnot. When you get a set of resident records with a similar injury like your own client, and you see the same lack of care, you can develop a case, to show that they didn't give a rat's, about what was going on in the facility, and they didn't try to fix it. And not only did your resident end up dying from this injury, but 20 other residents ended up dying from this injury. Not only is that discoverable, but that's admissible at trial. The pushback you're going to get from other resident records and other resident incident reports for similar injuries is obviously they're going to claim HIPAA, right?
Sure.
They're going to claim irrelevancy. What happened to Joe Smith is not relevant to what happened to your client. They're going to claim peer review, medical review. They're going to throw everything but the kitchen sink in their objections. But I will tell you, we have never lost on a motion to compel on this matter. Ever, ever, ever.
Let me ask this, because I've read quite a few of the orders that you've received on these motions that you're filing. And it seems to me a couple of these, or I might be wrong about this, but you're not wanting the nursing home to literally give you the entire file. Do you seek specific documents? Like, and we'll just say with the wound case, for example, like you're not wanting everything from every resident that had a pressure wound. Are you just, just give us the MDS, their assessments, and their care plans, or literally, are you wanting the entire file for the
Well,
residents?
let me tell you how we do it and why we do it this way. We will pick a time period, usually, a year before the admission to the resident's discharge. We'll start with a broader time period and we'll start with a broader request, which will literally seek, please produce all files of other residents during this time period who developed a pressure injury and or the worsening of a pressure injury. Now, what we'll get is, oh, goodness gracious, that's unfair. That's too broad. My goodness gracious. So in the spirit of discovery, and as evidence to the judge how reasonable we are, we will narrow it. We'll narrow the time frame to maybe 6 months before, 3 months before our client went into the facility or developed the pressure injury. And we'll narrow it to a certain set of documents. And those documents, for example, in a pressure injury case, would be the orders for treatment, the treatment administration record, the any skin assessments or skin records, whatever that facility. Every facility uses a different term. You got to be careful. Progress notes addressing any kind of wound or skin injury. So we're always willing, in the spirit of discovery, to narrow it to a reasonable time period and a certain set of documents. And you'll see in some of my orders, the judges we will propose to the judge, look, judge, how reasonable we are.
Right.
We'll take the minimum data set, the orders, the progress notes, and the skin assessments. How hard is that?
Right. And I feel like even today, I actually had to write almost a 60-page 6.4 letter, which is in Georgia, that's our meet and confer requirement before filing a motion, but it's about 60 pages. But that's one of the things is that, look, I understand like they're making the relevance argument, which in Georgia, we have a good case on point for that. I understand the HIPAA argument, which again, I think is a winner. But in terms of like, this is just too much, we'd have to have 15 people go in and no, like if it's electronic medical records now, you can literally search for residents that have this, like it takes 2 seconds. Like it's not, I guess what I'm trying to say is it doesn't seem like the overly burdensome or unduly burdensome argument really works anymore. But I threw I'm sorry, I threw us off track. Go ahead.
No, but you're right. You're still hearing the overly burdensome, harassing, typical boilerplate objection, but judges simply aren't buying it. Because we have EMR records, we have electronic medical records now that it's a stroke, correct? And B, sorry, not sorry, you killed our client. I'm sorry it's burdensome. I'm sorry you deem it as harassing, but maybe if you had taken better care of our client and the 40 other people that we're aware of based on your wound logs, we wouldn't be having this argument. Life is tough.
Right.
You brought this on yourself. And I'm telling you, judges aren't buying it anymore. They're just not. And let me throw in, so I'm clear, because I'm kind of grouping the other resident records with similar injuries. We do a separate request for incident/event/change in condition/SVAR reports, because what I find, Rob, is often we don't get a lot of pushback with that. We rarely do. So, for example, I have a fall case now where our poor lady fell like 3 times and the 4th fall resulted in her dying shortly thereafter. We got a fall log. They didn't want to give us the other resident records of falls, but they gave us the fall log. We have like 80 something falls in the 3 months, 80 something residents that sustained serious falls in the 3 months before. If you have that and you go to a judge to argue we're entitled to other resident records, I haven't encountered a judge yet that says, well, certainly not. There wasn't a problem there. So that's why you want to work hand in hand with these categories, because
and I think it's important, not to cut you off there. I think it's important too, because at least in my experience, they're going to say that the incident report, change in condition report, event report, SBAR are not a part of the records. So when you ask for records, we're not giving you those. So that's why, at least for me, of course, I steal everything from you guys, but at least for me, that's why I separate those categories, because I get that argument of like, well, Rob, the incident report is never part of the chart. Like we don't include that in there. So it has to be separate.
It always make it a separate request because it is a separate document. It may or may not be part of the chart. The SBAR, the situation is the notification to the physician, usually is part of the residence chart. But, you know, and the other thing you need to keep in mind, you're always going to draw these objections of HIPAA. And I mean, I even get attorney-client objections for other resident charts. I'm like, okay, dude, you know, come on. You
No,
know,
I got that not in this one I wrote yesterday, but I think a few weeks ago, and it's like, man, like you can't just make objections. Like
right.
like what's the factual basis? Are you a crazy person? Like,
Well, it just helps you, Rob, to look good in front of the judge, because the judge is, you're going to sit down and you're going to write your motion, and you're going to say that the ridiculousness of defendant's position is evidenced by an attorney-client privilege objection to, you know, a medical chart. I mean, they're not in any world is that protected by attorney-client. And
right.
we just argued a motion, a wound case against a hospital this week, where they're claiming some sort of peer review for the audit trail. I'm like,
Oh my
so
goodness.
you got, you know, keep it basic. You've got categories of documents that are gonna prove your case. I haven't really gone into why they help your case,
Right.
but it's the categories that we are just not going to not fight for.
Gotcha.
Um, so that's categories. So I've done the policies and procedures, training, personnel files, other resident records, and logs,
Hmm.
fall log, wound log, depending on what your case is. And the fifth category, I really thought hard about this, because we do get a lot of other documents like time cards that are extremely important. But I have found that when you ask for resident council minutes, and I don't know if everyone knows what those are, but resident council is a group that meets in a nursing home. By law, they have to have them, and it gives the residents and their families a chance to air their grievances and their concerns. And I have found if you really take your time and go through these documents, they're gold. Because back to a wound case, what I find is a lot of found my mother soiled in her diaper, you know, had to bring diapers to the facility, brought to the attention of the resident council. Or in a fall case, a resident says, I continually ring my bell for help and no one ever comes. Because these are the things that show. In a fall case, no one ever comes when you ring your bell, and we see all these falls, or a lot of the falls occur when someone finally gets up and says, I got to go to the bathroom, even though I need help, and they fall going to the bathroom. If no one's answering the bell, that helps your case, right?
Exactly.
If mom or, you know, the roommate's always in soiled diapers, or the family had to bring diapers to the facility, that helps your case in a wound case, because we don't have a dry resident. So resident council minutes, you need to make sure that you ask for those. I don't usually have to compel them. Sometimes I do, but once we make the argument that it's clearly relevant for these reasons, they usually give in on that.
Sure.
It's hard. It was hard to come up with like 4 or 5 categories,
No,
because
this is gold. Like you're right. This is. I mean, I know
yeah,
these are things that I ask for every time.
right. There's other things you're going to have to ask for, but if I will tell you this, I will not go take a wound nurse deposition without these 5 categories of documents.
Okay, hold on. So that's actually that's a good segue, because that's what I want to ask you now. So, so for me, sometimes, and I'm actually having to rethink this strategy because it's prolonging my cases.
Right.
But typically, what I would do is I file the case, I send my discovery, and I also send a notice of 30B6 deposition for just documents. Essentially, it's the Kozorotsky method of,
Right.
you know, who has possession of this document. So in other words, I can get on record and defeat all the objections they've made in terms of peer review and all that kind of stuff.
Right.
But the problem that I have had in the past couple years is that it takes 3 months to schedule the 30B6 deposition
Right.
document deposition, and
Right.
I'm not taking any other depositions. So I guess all that
Right.
long-winded to be said, what is your perspective on, do you wait to start deposing people? Like, what documents
Right.
do you have in hand before you start, or
Right.
does it matter?
Right.
Like, what's your
So,
typical?
right. You're never going to have, if you're trying to keep up with the discovery deadline, you're never going to have other resident records in time to start taking nursing depositions. You're just not. I mean, you're just not, because you got to send a discovery. They give you the BS answers of will supplement. You do your 6.4, they supplement a little bit. You still don't have the records. You do another threatening letter and say, then you got to prepare the extended 60-page motion to compel and brief that you're talking about. Then you got to wait for their reply. Then you got to wait for the court. You're just not going to have other resident records. So at a bare minimum, a wound nurse, a treatment nurse, a nurse that was involved in the fall, I'm going to have their personnel file, policies and procedures, and a wound log or a fall log. And I will tell the defense counsel that, they are impeding discovery. I'm willing to let the court decide on these bigger issues like other resident records, but I need to keep this case moving. And I want to depose the treatment nurse, and I want to depose the director of nursing. And at a minimum, these are the documents I need. And usually it works.
Mhm.
Usually it works. If you wait around for every document, you're going to get a motion to compel. You're never going to get a deposition taken until
That's me. That was me. Like I was doing
Right.
that. Like I was like,
Right.
okay, I want to get every single objection obliterated, file the dope
Right.
motion to compel, and then they end up
Right.
giving me the documents before we even get to the hearing, and there I am 6 months later.
Right. Well,
and
you're
I haven't
living in
taken a
la la
deposition.
land.
Yeah. Okay, but
You're-
see, this is why this podcast is fantastic. Okay.
Right. Right.
So, all right. So let me ask you this.
No, let me add to that. And I didn't mean to
Sure.
interrupt, but let me add to that. You got to figure out who you want to depose based on your case,
Mhm.
because it's going to be different in every case. In a wound case, the first person I'm going to want to depose usually is the wound nurse, the treatment nurse. I know other people depose the lower level first, but I just find getting right out of the bat, getting the wound nurse to admit they didn't follow policies, getting the wound nurse to admit the staging was wrong. I don't think you need a lot of other depositions at that point. But if you're deposing a DON, it might be a different set of records that you need. It might be more of an administrative attack or a global attack on the running of the facility. You
Right.
just
So you're
got to
doing like
figure out.
budgets and things like
Right,
that. Okay.
right. And that was the sixth category, was the financial information, because that is important for the global case, but it's not going to be important for a treating nurse, a wound nurse.
Oh, sure. Yeah. You're
Yeah,
not going
it
to
just
show a
depends.
CNA, hey, what do you think
No.
about these budgets?
No.
Right.
It's the DON is kind of a different issue, and that usually comes later in my cases.
Mhm.
I want to get the care down as substandard out of the mouth of a nurse before I start attacking, the way the facility was run and staffing and all that.
Okay. So then tell me about this then. Some people might have a request that's something like, give me every single one of your policies and procedures. Some people might be like, I want policies and procedures related to the injury only or whatever. Like, in other words, how laser focused are your requests? Like what typically, how are you, because you earlier kind of described like, I want everything in terms of time frame or whatever, and then I whittle it down. You know what I mean? Or do you start,
I
do you
do. And
start focused?
there's a great solution to that dilemma. There's two requests. You ask for all policies and procedures related to wound case, skin assessment, grade and scoring, prevention of pressure injuries, treatment. Okay. Then you have a separate request that asks for the table of contents for the facility. That way you get the policies will be relevant to your case off the bat. And then you get the table of contents. You make sure you didn't miss anything. You go through the table of contents, and maybe you forgot to ask for nutrition and hydration. So what we'll do is we'll ask for the relevant policies that we know are kind of everyday out there, fall prevention, things like that. But then we get the table of contents, and depending on the facility, there might be a whole nother, category of documents, policies we didn't even think of or we were unaware of, depending on the facility.
So let me ask you this, because this is actually like, now that you mention that, maybe I'm in the wrong here, but I laser focus my policy and procedure questions. Like, this is what I want. This is what I want. This is what I want.
Mhm.
Sometimes when they come back and go, we'll show you the table of contents and you just pick what you want.
Mhm.
And I could be wrong. I would love your opinion on this, but I get mad at that because like, man, I don't know what the substance, if it says nutrition or whatever, I don't know if what I want is in nutrition or if it's in, dietary or whatever. Like, and I don't want to have to
Right.
just tell you that I want everything. You tell me what the
See,
policy is.
but here's the problem with that, Rob. Every policy is every facility is different, the way they term things. And I'm going to give the benefit of the doubt to the defense attorney. Call me crazy after 37 years of doing this, but it may be that he really doesn't know what specific policy it is you're seeking.
Mhm.
I have them do that quite frequently. And I'm happy to say, okay, I'll highlight. What I do is I take my Adobe and I use the highlighter and I highlight everything. I send them an email and say, okay, to confirm as requested, here's what we want. And we want it by when the discovery is due. And it hasn't really been a problem. But I do, back to your point, I do have two separate requests and I can,
Right.
some are pretty clear. I mean, you would hope. Now I just have a case where there's no skin at all. There's no policies regarding prevention of pressure injuries. I'm like, okay, cool. That only helps our
Wow.
case, but
Right.
it's you send the two requests, see how they respond. If you think they're playing games, get mad. If you don't think they're playing games and the table of contents does show it's a little different verbiage, then work with them.
I see.
Because
Okay.
you're going to catch more flies with honey. You're
All
just going
right.
to catch more.
I feel like I'm too nice, but okay. Excuse me. Okay. So
Well, I've
let
never
me,
been told I'm too nice.
well, here's me. Like when I think of Suzanne Fink, it's like this. Like, and I hate to go Star Wars on you, but there's a bounty hunter named Boba Fett, and he's a
Oh, I
famous
know.
bounty hunter through the whole galaxy, and he has little braided pelts on his shoulder of all the Wookiees that he's killed, and that's what I think about you is you have a whole bunch of Wookiee scalps on your shoulder, which are the orders from the motion to compel
Right.
that you've filed, that you've just
Right.
accumulated through your career. And I think
Right.
you're the Boba Fett. Anyway,
Well, it
okay.
works. It
So
works.
let me ask this in the last few minutes that we have. Typically, what is yours? And speaking of deference to the opposing counsel, what is your kind of system? What's your perspective on when do you file the motion? How much leeway do you give them? How much time do you give people? Like, hey, I want to depose this person and I'll give you 2 weeks, or is it I'll give you a month to give me a date, or I want this document if you don't have it by tomorrow? Like, what is typically your perspective on that?
Right. I'm very shockingly, I don't know if everyone in my firm would agree with this. I can be very patient up to a point, and then up to that point, I just open up a big old can of whoop ass because I'm done. So the way it works for me, the minute their discovery comes in within a week or so, I'm going to review it. I'm going to figure out what they haven't given me, and I'm going to get a 6.4 letter out.
Okay.
Because we're all busy. But the longer it sits around, tick-tock, that 6-month discovery clock's tick-tock, tick-tock. And some judges aren't real amenable to extending it, right?
Mm-hmm.
So I'm going to get that 6.4 letter out. Then I'm going to get a response from them, and they're going to be whining and moaning and give me more time. The facility, I'll give them a little more time. And, because we all work, Rob, we all work with the same firms, right? I mean, for the most part, there's like 2 big defense firms in Atlanta that I'm getting this from.
Right.
And we'll have the conference. And to this point, I want to point out to the young lawyers out there that may be listening, always check the court. Some courts have standing orders about you are not allowed to file a motion to compel until you've called this court and you've had a conversation with us. Always make sure there's no outstanding order or rule by your judge that you have to have some sort of conference, either with the court or whatever, before you let all hell break loose with a motion to compel.
Right. Because that's how, at least in Georgia, that's how it works for everybody outside of Georgia, is that you have to have a meet and confer at minimum telephonically to go over what the problems are. Okay. So you right off the bat, within a week of getting discovery, you're sending off and we're saying 6.4 for everybody outside of Georgia. That's our meet and confer letter. You're sending a meet and confer letter saying this is what we think you did wrong. You give them a week or so to respond to that. Then you have
I give them, I'm reasonable, Rob. Let's because this is something I'm gonna put in front of the judge later on. I give them 3 weeks. I do a 6.4 and I said, you have 3 weeks to supplement. And if I don't hear, I'm happy to discuss this with you. By the way, here are, 30 orders where these very issues and 10 of them are with your firm and 5 of them are with you. And 2 of them are in front of the same judge, but okay, these are the orders on these very issues. I give them 3 weeks because when I go to the judge later on, I'll say, Your Honor, look, I gave them plenty of time to supplement and they didn't supplement. And Your Honor, I even narrowed 6 of these requests. I mean, look how reasonable we are. But I am known as the lawyer on these nursing home cases to keep the cases moving because I have a little bit of OCD on this. But if you keep it moving, you're going to know. You're going to know when that defense lawyer is just full of you know what.
Right.
You will know when you've had enough. And that's when I just I start working on the motion to compel. And I don't send them a copy and say, I'm going to file this. I will say after a 6.4 and a chit chat, and I'm getting ready to file a motion to compel. And that's it. And you file the motion to compel, they have 30 days to respond. And I will guarantee you, before those 30 days are up, after you file your motion to compel, you're going to start getting supplement. Inevitably.
Right.
They're going to start supplementing because they don't want to look fool in front of the judge either. And it shows the judge that you've been reasonable. You've given them time. They're still withholding documents. You've given them, my goodness, you've given them an outline. You've given them a template where this has been, brought before this very court before.
Mm-hmm.
And so you're in a great position at that point. But no, I would say it's the motions to compel usually come within 3 to 4 months after the suit's been filed.
Wow. I can only aspire to those things. Yeah.
Well, in a perfect world, we're all busy. The problem is no one likes doing this. It's tedious. It's boring. It's redundant. But I will tell you, at the end of the day, it's the way you get the value of your case up, up, up. Especially if like you're on a mediation calendar and we have a mediation schedule for June, and we've got all this outstanding discovery with a firm I will not name that we always have. Most of these orders are with. And I said, you can let your claim rep know that if mediation fails within a week, we're going to be filing this and we're going to seek attorney's fees because y'all knew. You knew.
Yeah. Especially you, Suzanne, who has the Wookiee pelts. So many Wookiee pelts. Well,
Lots of orders.
Yeah. So this has been the fastest 30 minutes that I've ever had a conversation with someone on this show. I think
You say that to all the girls.
No. This has been fantastic, Suzanne. Thank you so much for coming on and sharing your perspective. I really appreciate it.
It's been fun. Always fun to see you, Rob.
Thank you. Well, folks, I hope you found this episode educational, perhaps even entertaining. If you have a suggestion for a topic that you would like me to discuss, please let me know. If you have an idea for a guest that you would like for me to talk to, please let me know that as well. New episodes of the Nursing Home Abuse Podcast come out every single Monday, wherever you get your podcast from. You can also watch the podcast. That's right. You can watch our smiling faces on YouTube or on the website, nursinghomeabusepodcast.com. And with that, folks, we'll see you next time. Thanks for tuning in to the Nursing Home Abuse Podcast. Nothing said on this podcast, either by the host or the guest, should be construed as legal or medical advice, nor is intended to create an attorney-client relationship between the host or their guest and the listener. New episodes for now are available every other Monday on Spotify, Apple Podcasts, or on your favorite podcast app, as well as on YouTube and our website, nursinghomeabusepodcast.com. Again, that's nursinghomeabusepodcast.com. See you next time.